Good day everyone, I am Cindy ABJELINA and I am here to present to you my report about the Law on Obligations and Contracts Chapter 3. But before I proceed, let us hear first my objectives. So my objectives is to identify the different kinds of obligations and contracts. I enumerate the ways of distinguishing an obligation, enumerate possible applications of contracts in tourism and hospitality industry. On the next slide, as we can see here, is the quick overview of the law. So a person desiring to engage in business in tourism, travel, and hospitality industry will meet certain obligations. So agreement arising from contracts will have to be made, and potential breach from these will be encountered. Therefore, there is a need to study the fundamental principle involving law on obligations and contracts. So on the next slide, we have here the Article 1156, which is an obligation is juridical necessity to give, to do, or not to do. So an obligation is a legal duty, however created, the violation of which may become the basis of an action of the law. So every obligation has four different elements, without which no obligation can exist. So first, we have here an active subject, also known as the oblige or the creditor. So who has the power to demand the prestations? Second one is the passive subject, which also known as the debtor. So who is bound to perform, to demand the prestation? So number three, we have here an object or the prestation. So which is an object or undertaking to give, to do, or not to do. And the last element we have here is the juridical or the legal tie, the vinculum which binds the contracting parties. So the juridical tie or the vinculum is based on the sources of the obligations arising from either the law or the contract. So it is important to identify the prestation in certain obligations, because once the prestation is identified, you can determine who the passive subject is, whom the active subject can demand the fulfillment of the obligations. So on the next slide, we have here the Article 1157, which is obligations arise from: first, we have the law; second, contracts; third, quasi-contracts; fourth, acts or omissions punishable by law; and the last one we have quasi-delicts. So in the next slide, there are only two sources of obligations. First is the law, and second is the contracts, because obligations arising from quasi-contracts or crimes in the number 4 Article 1157 of the Civil Code of the Philippines and the quasi-delicts are really imposed by the law. So a contract is a meeting of the minds between two persons whereby one binds himself with respect to the other, or to give something or to render some services. So that is contract. So when we talk about quasi-contract, it refers to a lawful, voluntary, unilateral act based on the maxim that no one shall unjustly enrich himself at the expense of another. So, on the civil obligations arising from criminal offenses are governed by the by the provisions of the revised penal code, such as restitution, reparation of the damage caused, the indemnification or consequential damage, and the second is by the provision of the civil code on the damages, or which is moral, exemplary, or and nominal damages. So quasi-delict, also known as culpa aquilina, is any act or omission which causes damage to another, being fault or negligence, and there being no pre-existing contractual relation between the parties. So on the next slide, we have here the classifications of obligations. First is primary classification of obligation under the Civil Code. First, we have here the pure unconditional obligations, which is in Article 1179 to 1192. Second is obligations with a period, Articles 1193 to 1198. The alternative to 119 to 1205, and facultative obligations in Article 1206. the joint and solidarity obligations in Article 1207 to 1222. So divisible and indivisible obligations in Article 1223 to 1225. And the last one, we have here the obligations with a penal clause, which is in Article 1226 to 1230. So in the next slide, we have here the secondary classification of obligations under the Civil Code. We have here unilateral and bilateral obligations in Article 1169 to 1191. The real and personal obligations in Articles 1163 to 1168. The civil and natural obligations in Article 1423. And the legal, conventional, and penal obligations in Article 1157, 1159, and 1161. In the next slide, we have here the discussion about the said articles. So a pure obligation is which is not to any condition and no specific date is mentioned for its fulfillment and is therefore immediately demandable. So for experience, Ariel is promises to pay Brenda 1,000. So that is example of a pure obligation. So a conditional obligation is one whose consequences are subject in one way or another to the fulfillment of a condition. So for example, Carol promises to pay 1,000 if Darren remains to become an outstanding employee of the hotel of the month of May. So that is the example of a conditional obligations. So an obligation with a period is one whose consequences are subject in one way or another, so to the expiration of the said period of time. So joint obligations are those where, although there concur two or more creditors and debtors, so in one and the same obligation, there is no right to demand nor a duty on the part of each the latter to render entire compliance of the entire obligation. So when we talk about solidary obligations, are those in which concur several debtors or creditors or both, or which each creditor has the right to demand and each debtor is bound to perform in its entirety the prestation constituting the obligation. So on the next slide, we have here the modes of extinguishing obligations. So in Article 1231, obligations are extinguished by payment or performance, by the loss of the thing due, by the condonation or remission of the debt, by the confusion or merger of the rights of the creditor or debtor, by compensation, and by innovations. So other causes of extinguishment of obligations such as annulment, recession, fulfillment of a resolutory condition, prescription, and governed elsewhere in this code 11568. So on the next slide, we have here the discussions of the said laws. So there are other causes of extinguishment of obligations which are not expressly provided under the above provision. So that is also extinguished obligations which are purely personal in character, such as partnership and agency. Obligations may also be extinguished by the happening of a fortuitous event or by will of one of the parties in some contracts such as partnerships or agencies. So fortuitous event, also known as force majeure or casu fortuitu, are terms which exempt an obligor from liability. So these are extraordinary events and are not foreseeable or avoidable. Events that could not be foreseen or which, though foreseen, were inevitable. So in Article 1174 Civil Code of the Philippines, it is therefore not enough that the event could not have been foreseen or anticipated, as is commonly believed, but it must be one impossible to foresee or to avoid. So fortuitous event may be produced by two general causes which are by nature, such as earthquakes, storms, floods, tsunamis, and etc. And the second one is by the acts of men, such as armed invasions, attack by land bandits, governmental prohibitions, robbery, and etc. On the next slide, we have here the contracts. In Article 1305, a contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So the next slide, we have here the discussion of the law. So the essential elements of the contracts are as follows. First, we have consent, which is manifested by the meeting of the minds, and the offer and acceptance upon the thing and the cause which are constitute to the contract. So the offer must certain and acceptable absolute. Second one, we have here the object certain, which is the subject matter of the contract, and the cause of the obligation, which is established. So on the next slide, we have here the characteristics of contracts. First, we have the mutuality contracts. So what is mutuality contracts? So it is the validity and performance that cannot be left to the will of only one of the parties. So next one, we have the autonomy contracts. These are the parties are free to stipulate terms and provisions in a contract, or as long as these terms and provisions are not contrary to law, morals, good customs, public order, and public policy. Third one, we have relativity of contracts. So contracts are binding only upon the parties and their successors in interest. So exception is the stipulation in favor of a third person, as in a beneficiary of an insurance policy. So the fourth one, we have consensuality of contracts. So contracts are perfected by a mere consent, and no form is prescribed by law for their validity. So exceptions are the real contracts such as pledge, chattel, or mortgage, and the contracts covered under the statute of the funds. So the last one, we have here the obligatory force of contracts. So these are the obligatory. It constitutes the law as between the parties who are compelled to perform under the threat of being sued in the courts of the law. So we have here also the classifications of contracts, which is in this slide. So first one, we have here the according to their relation to other contracts. So first, we have preparatory, or those which have their object of the establishment of a condition in law which is necessary as a preliminary step towards the celebration of another. Examples are the partnership, agencies, common carrier, and insurance. So second one, we have here the principal, or those which can subsist independently from the other contracts and whose purpose can be fulfilled by themselves. Examples are sale, lease, common carrier, or insurance. So the third one, we have here the accessory, or those which can exist only as a consequence of or in relation with another prior contract. So examples are pledge and mortgage. So the second one, we have here according to their perfection. So we have here consensual, or which are perfected by the mere agreement of the parties. So examples are lease or the sales. So the next one, we have here the real, or those which are not only the consent of the parties for their perfection, but also the delivery of the object by one party to the other. So examples are the comodato, deposit, or the pledge. And the third one, we have here according to their form, which we have here the common or informal, those which require no particular form, which is one of the examples is the loan. So the second one, we have here the special or formal, or those which require some particular form, and examples of this is the donations, charter, mortgage. So on the next slide, we have here the fourth one, which is according to their purpose. First one, we have here transfer of ownership, which are one of the examples is the sale. Second one is the conveyance of use. Examples is commendatum. And the third one, we have here the rendition of services. Examples are the agency, lease of services, and labor. So the fifth one, we have here according to their subject matter. We have here things and services. So examples of things are the sale, deposit, or the pledge. And the services, we have here the agency, lease of services, and labor. So the sixth one, we have here the according to the nature of the vindiculum which they produce. First, we have here unilateral, or those which give rise to an obligation for one of the parties. So examples here is the comodatum and the gratuitous deposit. So the next one, we have here the bilateral, or those which give rise to reciprocal obligations for both parties. So examples here are the sales and the lease. The last slide, we have here the seventh one, which is according to their cost, and under this is the onerous and the gratuitous. The eighth one, we have here according to the risk involved, the commutative and the aleatory. And the ninth one, we have here according to their names or norms regulating them. We have here the nominate and the innominate. So I guess that would be all for my report, ma'am. Again, I am Cindy ABJELINA from BSHM 3A. Thank you.